Okay, good afternoon, everybody. I'm Bill McGrath. I'm the Associate Director of the Center for Intellectual Property Law here at John Marshall. Thank you for coming and welcome. A couple things I would like to do first. I first wanted to mention we're very pleased and proud to about this development, which is the U.S. News and World Report rankings for graduate programs came out, and we have risen this year for the second year in a row. We are now ranked, we went up 4 spots from number 19 to number 15, so we're very pleased about that. I also want to mention that our director, Darrell Lim, couldn't be here with us today. He's out in New York presently. He's on sabbatical doing intensive research and other things out in New York, so he sends his regards to everyone. I also wanted to welcome a few distinguished guests with us today. First is Professor Sarah Bernstein, who's a design law and intellectual property law a professor out at Oklahoma University, who's in town, and Professor Arthur Yuan from John Marshall, who runs our patent clinic, is here with us today. So I wanted to welcome you and all of you. So now I have the honor to introduce our speaker today, Christopher Carani. Chris got his JD at University of Chicago, and he is a partner at the McAndrews law firm. Chris practices all areas of IP. He's one of those rare birds who crosses over between patents, design patents, copyrights, and so he can do it all, a Renaissance IP lawyer, so to speak. This is a great time to be an expert in design law. I mean, starting with several years ago when the Federal Circuit came out with the Egyptian goddess case involving design patents, which hadn't been a focus much prior to that for a long time, at least to my knowledge. Maybe Chris will correct that, but that kind of got the ball rolling. Then in recent years, we've had the whole Apple versus Samsung debate and the Supreme Court rulings. And then to add to the mix, just last year, we had in the copyright side of design, the design world, came the Supreme Court's Star Athletica case. So there's a lot going on in the world of design law. Chris is also an adjunct professor over at Northwestern, where he teaches intellectual property law and policy. He is one of the nation's leading experts, I think everyone would agree, in the field of design law. He's the author and editor-in-chief of this book called Design Rights, Functionality and Scope of Protection, which happens to be the name of today's talk. It's a relatively recent book, just came out last fall. So in any event, that's what he'll be talking to us about today. So the last thing I want to mention is that after the talk, we have a little reception. If you can stay around, it'd be a nice chance to talk and network with each other and talk to Chris. And so without further ado, Chris Carani.
Thank you, Bill.
Thank you.
Thank you, Bill, for the kind introduction. Congratulations to the school on the uptick in the rankings. It's certainly well-deserved. Having had my practice in IP law here in Chicago for the last 20 years, certainly John Marshall Law School has been a guiding light for IP practice here in Chicago and for the rest of the nation. So it's good to see, and it's certainly welcome. It's an honor to be here to be able to present this book. The topic on design rights, as you mentioned, it certainly has been thrust more into the limelight for a host of reasons. But when you do have something that's being thrust into the limelight with respect to design rights, it also sheds more light. And there's various areas of the law and design law that really hadn't been explored too deeply. And even to this date, there's many aspects more so than in trademark law or utility patent law, copyright law. I would say in design rights probably more than any other IP area. Certainly semantically speaking, as far as the terminology that we use worldwide, there's no doubt that design rights, that the terminology that's used is the least harmonized of any of the IP rights. And as we go through that, we'll hear, for instance, in the United States, we call them design patents. But that is the extreme minority of any of the countries that would call them design patents. Most of the rest of the world will call them registered design rights, industrial designs, design models. So even the terminology used for the basic right itself, there's great discord. That certainly then carries over to two critical issues about what do you get when you get a design right, and two of those two critical issues are functionality and scope of protection. Functionality was of great interest to myself, coming at this being formally trained with between an engineering background and also practicing utility patent law. That many of the cases that we're working on, there seemed to be some type of appearance aspect to the product. When we talk about these various areas of IP that I've sort of had experience in, because I deal with a lot with consumer products. Almost with all consumer products, you're going to be dealing with some type of appearance, whether it's going to be trade dress rights, potential copyrights, potential design rights, and of course utility patents and trade secrets that could be implicated. How I got initially involved in design was as a researcher at University of Chicago with Professors Landis and Posner, who were very involved in protecting three-dimensional sculptures. We're doing a lot of research on that area, so I was serving as a research assistant in that regard. Then I was clerking for Judge Pallmeyer across the street at the Northern District of Illinois, and one of the cases I had was regarding trade dress. Soon after I graduated and came out from my clerkship and began working at McAndrews, I had a design patent case that was on my plate. So putting those three areas together, I was often the associate. What are you bothering with this design law? Let's focus on utility patents, real patents. I've heard that terminology. But my curiosity was certainly piqued through that. And so all the while I've been sort of focusing on design rights. You certainly mentioned that a watershed moment was Egyptian Goddess in 2008, September 22nd, when the Fed Circuit, the en banc Federal Circuit, had its only an en banc decision dealing with the issues of claim construction and infringement. But the seeds were really planted 5 years earlier to that, when many of the handful of protagonists in this area of design law in the U.S. were writing amicus briefs to the Federal Circuit saying, there's problems here. There's problems in the design law and the design law jurisprudence. They were all sort of rebuffed, and they never made it past the stage of the petition stage. But much to our surprise, when we came forward with Egyptian Goddess, and there was at the petition for a rehearing en banc, at the petition stage, we had written amicus briefs in favor of this, and when the court came back and says we're going to take on this case, they didn't just attack the particular issue that was before the court. Lo and behold, they went through on several other issues that we had been sort of pressing to the court in the years preceding that. So that was a very sort of rewarding moment to know that the court was actually listening to these pleas. That particular issue was the scope of protection issue with respect to claim construction and how you might set forth design patent claims. So let's just sort of take an example. This is, I guess, the spork. I've known this called a spork, but as I was preparing for this, the example actually has a little knife on it, so I've sort of called it a spork knife. I don't know if I coined this term. I won't take credit for it, but it just seemed like it fit. So the spork knife. Now, one of the first questions is, if you're thinking about this, oh, well, a design patent, we hear this notion, oh, it has to be ornamental. It's one of the statutory requirements for a design right. It has to be ornamental. Is this ornamental? Is going to be one of the threshold questions for subject matter eligibility, for subject matter compliance with the statute itself. That will be one issue that we're going to sort of want to tackle. Then there's this sort of second issue that has crept up and is pervaded by this proclamation by Judge Lurie that a design patent only protects the novel and ornamental features of the patented design. Okay, the features. So now we're going from the first issue is a macro issue. Do you get a right at all? The second area where we're seeing functionality is, are there any portions of the design which should be perhaps disregarded, or what do we do with them? one of the notions in the book was to attack this notion that you should be doing any atomization of designs, dividing them up and eliminating features. We know that we never disregard old features in a design. You can have an amalgam of old features as long as you combine them in a novel way, a novel appearance. That's something that will be provided protection. So this idea that it only protects the ornamental features, you're wondering what does it not protect functional features, is sort of what's left in this. So we'll talk about how that is impacted. But if you were to use that with the fork, if it doesn't protect the functional features, do you not include the knife portion? Do you not include the tines of the fork? Do you not include the bowl of the spoon? What does that mean? What do we mean by features? Are we talking about the manifestation, the physical manifestation of that feature, or are we talking about the underlying functional quality? Let me give an example. If we have a hinge, are we talking about, on a hinge on a door, do we disregard the hinge itself? Or do we just disregard the fact that there's some type of swivel characteristic, a purpose or underlying functional quality that goes along with that? So this has caused great havoc with this idea of looking at a design and sort of treating it like Swiss cheese, where you just start eliminating particular features. We'll get into those problems. So where this sort of percolated in my mind for a better part of a dozen years in practice is when in 2014 I wrote this first article on the left for ABA, the landslide, which was in the materials that was handed out. Then you sort of fast forward to 2017 was tasked with preparing this book on design and on design functionality. And we'll see that during that particular time frame that the law has certainly evolved, I suppose you could say, or at least taken some different turns. So I wanted to speak just a bit about the book here, because one of the aspects, the great joys of practicing in the area of design law, and I say design law in this sort of umbrella term. I'm not using it just with respect to design patents, but in design. But as the joys is that the opportunity it provides to sort of delve into design itself and the rich history of industrial design, graphic design. And then you get to learn about the different design movements and the protagonists in the particular area. So I'll start with a few famous quotes from three luminaries of 20th century design. Here's Dieter Rams saying, "Good design makes a product useful." Okay, so we're already seeing that usefulness and that melding of form and function. Secondly, Charles Ames, design is a plan for arranging elements in such a way as best to accomplish a particular purpose. So we have purpose, we have usefulness, and then of course this famous Louis Sullivan quote, "Whether it be the sweeping eagle in his flight or the open apple blossom, the toiling workhorse, the blithe swan, the branching oak, the winding stream, at its base the drifting clouds, over all the coursing sun, form ever follows function." So it's clear from these profundities that usefulness, intended purpose, functionality are central principles, guiding lights for designers. They're always there. And so much of this aspect, and this is my personal opinion on this, much of these aspects to try to weed out functionality when you're looking at design, it's a fool's errand. And we'll go into that as to why that is and why you cannot divorce out certain aspects without bastardizing the design, the actual piece of article manufactured, the design that the designer has created themselves. So here we are as far as semantics. I don't want people to get hung up on when we talk about design patents, design registrations, roughly talking about the same. Design patent claim, others, if you're not coming from practicing US, you might just consider them just a design. Overall appearance, roughly equals overall impression. Ordinary observer, the informed user. These are all terms that you hear more outside the US, but they're rough equivalents. And the book itself, because there is a paucity of jurisdiction here stateside on the issue of design patents, what was really interesting was going outside, because this really surveys 27 jurisdictions throughout the world using a similar fact patterns and running those hypos through those different jurisdictions to try to find some answers to some of these critical questions to better inform our own policy here in the US. But if you're using these particular terms, claim construction, scope of protection is really what is the scope of the claim that we're talking about when we're talking about what the design right. So for those of you who understand that we have some students in the audience that here also that when we're talking about ways to protect appearance, at least in the US, we've got design patents, we have trade dress, we have copyright. We're going to be focusing on design patents today. We're not going to bleed into trade dress or copyright. It is interesting to think about functionality because each one of those other two rights, trade dress, has the Lanham Act says that it has to be non-functional. It's actually codified that way. Copyright law has the merger doctrine, where we're talking about where there are sort of limited ways in which to express something, that sort of the idea merges, the expression merges into the idea. That it's not that there are aspects that are not protectable in the separability doctrine, as Professor McGrath just mentioned with last year's Star Athletica case. We're not going to go there. We're going to be focusing on design patents. Now, this terminology of functionality, it's used, the same phrase is used in copyright law and in trade dress law. You see that term used in all three of these. And so there is often a tendency of jurists or practitioners to start borrowing concepts and using functionality case law from trade dress law and using functionality concepts from copyrights and trying to bring them in. That is improper to do. There are all sorts of underpinnings that for each one of these rights, there are fine balances, and to just say you can grossly import the functionality doctrine from trademark law or from copyright law into design patents, I think that leads to wrong results. Each one is a careful balance with respect to the term that's provided, the scope of protection, the type of remedies that are provided, the policy reasons that are underlining each one of those. They're different, and therein lies good reasons why there's differences in how to treat the functionality doctrine. So I look most of this as sort of a continuum. And from things that are purely artistic, like our beloved Picasso here in Chicago at the Daly Center, all the way to things that are said to be purely functional. So what's the big to-do here? Why are we concerned about this functionality doctrine? Well, so goes the theory is that if we were to provide a design right on the ball bearing, okay, on that particular spherical, perfectly spherical shape, you would have effectively a de facto monopoly on that particular functional idea of having the ball bearing. So we want to not permit design rights to be used as a backdoor way to protection, utility type, idea type protection at that level. So where there are no other ways to execute a particular idea, if you were to provide design protection on that particular shape, that particular form, that particular configuration, that could lead to this type of unwanted monopoly. Now, things that are on the other side of the spectrum, there are many jurisdictions in the world where if something is purely artistic and doesn't have any sort of, is not tied to some article of manufacture, but is purely an artistic effort, they won't provide protection. So, to me, it's really, everything in between is what we're talking about, things that are potentially protectable subject matter. But of course, the really interesting area is once you get close to the line, okay? You get closer to that line, you're dealing with, for instance, that scissors, or you're dealing with screwdrivers, things that have a high degree, nuts, bolts, things that have a high degree of functional qualities. But the question then is that particular appearance the only way that you could do that? If you were to provide a design right on that, would that provide effectively a de facto monopoly on that function itself? But all of these things, if you look around the room, almost everything in here is potentially subject matter. Whether or not it's not, novel or non-obvious is a different question. But as far as potentially protectable aspects, there's quite a few things that are, and very few things that are actually not going to qualify for subject matter for design protection. So a couple of hits on design patent prosecution, just to lay a little groundwork before we get to the meat of the matter. One claim per design patent. Duration is 15 years from issuance, not from earliest filing dates. For those utility patent practitioners out there, it's from issuance. No maintenance fees, issuance 9 to 12 months, depending on what art area you're in, but 9 to 12 months is about right. And there is this continuation practice that's available, which is so critical, I think, to robust and enforceable design protection. Design rights can protect the shape, the surface ornamentation, color, combination of those. So if you start running through those variations, you can get some significant protection with design. As far as statutory requirements, novel, non-obvious, ornamental. Novel, the first two are quite well known. Ornamental is sort of this curious word that finds its way into the Patent Act. And we'll talk a bit about what does ornamental mean. When you're looking at design patents, there are some fundamental rules that I think are helpful just as bedrock here, is that solid lines are part of the claim, dotted lines are not part of the claim. So very often you'll see what we call partial designs. You'll see portions, you'll have a coffee mug, and you'll have only the mug portion in solid lines, the handle will be in dotted lines. That means that the claim is only directed at the solid line portion, at the mug portion, not at the handle itself. And this can be quite important for your scope of protection that you're trying to claim. We're only going to focus on the solid line portions of the claim. For instance, here in this webcam, Microsoft webcam, the bottom portion is disclaimed because it shows in dotted lines. So whether it's a C clamp or a J clamp or an L clamp, that's not going to matter. When it comes to infringement, the right that we're going to be comparing is only the upper housing. So it's important to note that we're not looking at these other features, or these other aspects, we're only looking at that portion which is designed. Here's another example with the chair. So if you give an example, if you have the design patent with the claim on the left, and somebody comes out with the accused product of basically a replacement toggle for this baby bottle, and they use the product on the right, there will be no infringement there. And this, even though the toggle is identical to that which is shown in your design patent, it is not going to be infringement because the overall appearance of the full bottle is not substantially the same as the toggle on the right. This seems sort of like a simple concept, but I'm always amazed when you go through the jurisdiction that jurists or even practitioners seem to get tripped up on this. This is not like a copyright, and I think some of this might come from post hoc articulation of a trade dress, where you've got your product and then you sort of select what are the elements of your packaging that you want to try to establish secondary meaning, or you want to try to establish is non-functional. Here we have a claim, so you're locked in on that particular claim. Or difference from the copyright. Say you have a book, 20 chapters, somebody copies chapter 17, you can still have copyright infringement. Someone doesn't have to copy all 20 chapters. You can have rights even in a constituent portion thereof. The design rights, it's not like that because it is the amalgam, it is the ensemble of everything that you've claimed. And this is going to be important when we talk about functionality and even when you talk about novelty. We don't go through a design and say, well, a circle is old, so we're going to get rid of the circle. Okay, we don't say an oval is old, so we're going to get rid of that. A line is old. You don't go through that divide and conquer. Why not? Because the right that's being afforded it's an amalgam. It's the combination of all those elements. If you're practicing utility patent, if you have a utility patent, a claim on a car, and there's A, B, C, D, E, and E is for having wheels, we don't sound alarms and say, wow, someone has got protection covering the wheel. No, because we know that it is a combination of A, B, C, D, E. It seems super simple in the utility patent world, but there's a continuous desire to divide and conquer design claims and try to atomize them into parts and say, well, we're going to separate the old from the new. We're going to separate the ornamental from the functional. When the only consideration should be what is the overall appearance of that, and does that pass statutory muster, either being novel, non-obvious, and ornamental. And this is why you see in a lot of claiming where, if you're going to be doing strategic design claiming, you might want to file on individual components of the design because there are no independent rights in any constituent portions. So the other bedrock thing to I think have in place is, what is the test for infringement? Fortunately, there is only one Supreme Court case regarding design patent infringement. This goes back to the famed 1871 Gorham v. White, sort of the granddaddy of them all, where the court has its first opportunity to set forth what should be the test for design patent infringement, even answered some more fundamental questions that, should we even have design patents? Since their inception coming into law in 1842, the Patent Act, this was the first opportunity in 1871 to go forward. And the Supreme Court says, yes, they provide a meritorious service to the public and trying to encourage the decorative arts and finding groundings in the Constitution, but also came forth with what should be the test, rejected the notion that we should be using the eyes of experts, and rather said we should be using the eyes of an ordinary observer. So this is where we get this, what we call the ordinary observer test in design patent law. And also the court holding that the two designs don't have to be exact, but rather sort of rolls in a doctrine of equivalence there and says that the two designs must be substantially the same. So we have a substantial identity is that being the requirement. So as far as the facts here, you've got Gorham on the left, the accused product on the right. After, when we have the reception, a good friend of mine who's been a head of the Industrial Designer Society of America, one year he was doing some research on this particular case and actually came across the famed Gorham and White's spoons at a silversmith's shop. And so I have, and I brought them with me, so they're in my office here in Chicago, but I actually brought them with so we can sort of take a look at the Gorham patented design and the White accused design on the right. So is there infringement? This is what the court was tasked with. One of the key parts to this whole analysis is to always, when you're doing designs, is to not just look at two things, but rather do it in a comparative aspect. Put that prior art, find out what is the frame of reference for the analysis. How close is too close? Well, compared to what? So, for instance, do Professor McGrath and I look alike? Well, compared to a pack of elephants, we look very much like each other. But compared to, let's say, he has a twin brother, then we don't look like each other. So this is a departure, I would say, from utility patent law. We don't really do our analysis of all elements rule or even doctrine of equivalence against the prior art. So it's fundamentally different in the design context that we're looking for this frame of reference. Now, if the prior art's very close, then those differences between the two designs become much more illuminated, okay? Whereas when it's pitted against the very disparate prior art, it doesn't. And that was what the finding of the court was infringement in this particular case. This prior art, incidentally, is from my own independent research. It's not found in the case itself. So this is sort of looking at the time of 1870s, 1860s, what is the flatware is going to look like on the market. And this is what you might have found, something much more ornate. But you get the concept between this idea of crowded art, close art, how it impacts the analysis. So the test when we talk about infringement is what is the overall appearance of the patented design substantially the same as the overall appearance of the accused design in view of the prior art. Notice in both of those we're looking at the overall appearance. Now almost every opinion gives lip service to this idea of the overall appearance, and then in the next breath they're chopping up the design into pieces and separating old from new and ornamental and functional. It betrays the initial, the idea, the design of the designer when we take these things and put them into pieces. Claim construction. And this, going back to that sort of 2008 Egyptian goddess case, you've got to think about this from 1995, sort of from the Markman decision, the Supreme Court, where it says, okay, it's for the courts to do these claim constructions. Well, it was talking about a patent, and that's sort of one of the unfortunate aspects about design patents, is that they're considered patents. So they get lumped in with a lot of case law or policy that really doesn't apply to designs. There's, Professor Janice Mueller and Daniel Breen wrote a really interesting article about whether or not obviousness should be applied. Section 103, it doesn't make any sense. Does KSR have any application to designs? Does it really make sense, any of those, the rules articulated in there, do they really graft well onto design patents? I would argue they don't. The design patent claim construction, next thing we know, we've got designs being thrown into this mix of trying to articulate, have written claim constructions regarding design patents. So, for instance, if you're looking at the patented design on the bottom, the accused product on the top, instead of just leaving this as an ordinary observer, an ocular analysis of the two, what we saw was, let's just scoop here, was courts taking those drawings, and let's give an example here with the ceiling fan, instead of just saying, do these two things look substantially the same in overall appearance between the two, what courts were doing was issuing these extremely long verbalizations of the claim, writing out, and I can remember being a law clerk and being asked to do a claim construction on a design patent. This is a mighty effort. This is over 500 words. Even if you're just talking about sort of, you know, from rules of pragmatism or desires of judicial efficiency, does this sort of make sense? Because at the end of the day, it's going to be a visual test. But this can be harmful of going through and turning a design patent into a checklist. This is why we don't claim them that way. This is why we claim them with drawings and not with particular words. Words are ill-equipped for the task. If I was asked to describe the Mona Lisa and Professor McGrath was going to describe the Mona Lisa, inevitably we're going to have two very different articulations. The better way to describe what the Mona Lisa looks like is to show the Mona Lisa. Same thing with ceiling fans. The better way is to do that. Otherwise, you end up with the court here trying mightily to come up with a way to describe this using terms like fin-shaped, sweeps, a partial sphere, running pointed star, generally football-shaped, a sharply angled, rounded corner. You wonder if that's at all helping the situation and why we're even going down that path in the first place. On the other side, you had courts just sort of saying, the drawings speak for themselves, and there was certainly plenty of Federal Circuit opinions going in that direction. But you never knew when you went into court whether or not you were going to get this long checklist or you're going to get sort of a short and sweet reference to the drawings themselves. So as we come out of all of this, the court has said, we're not going to go down this path of articulating what the design is. Rather, the verbalizations as a general rule should not be attempted. Okay, so let the images speak for themselves. And I bring up all this background because we go into functionality and we're going to talk about this elemental type of approach. We've learned about the test. We've learned about the ability to use dotted lines and you're left with what you set forth in solid lines is your claim. We learned about the test. The overall appearance is critical to that. And we're talking about how the court is saying we want to have everything, and everything is part of the claim. Everything you've shown is part of the claim. Words, you might be leaving out aspects of that. It's almost impossible to capture every spatial relationship in a design by using words. And even if you could, the drawings are probably the more efficient way in which to do that. So what we've seen after Egyptian Goddess is what, if I was a law clerk and I had a choice that I ever have to sit down and write a long claim construction, or I could just refer to the drawings, probably would choose the latter. And we've seen the district courts doing exactly that, just saying, we're going to elect to rely upon the drawings and the patent. That is what the claim is covering, instead of going into articulating. So with that as backdrop, we sort of get into the idea of what really matters in a design. When I look at a design patent, and I'm opening the file and looking through it, I look at everything as faux. What I mean by that is F-A-U-X. If I see something that is a light switch, I don't look at that as thinking as whether or not it swivels or not. If I'm working on a utility patent case, I'm very interested in that. But on a design case, it's effectively static and what you see. It doesn't matter if it works. In this particular case, here is a step stool. Now you might have used this, you might have picked it up at Target or at Menards or Home Depot, and you probably know that those piano hinges actually swivel so this thing can fold up. But when you're looking at this, it doesn't matter from a design point context whether or not that does or does not swivel. So it is all and only about the aesthetic appearance of the overall appearance. So that is sort of one thing to keep in mind. So it is not covering any underlying functional qualities or characteristics of a design. It's only the outward expression, the appearance that we're looking at here. It's the appearance that matters. And design rights, this cannot be said enough, that they do not protect general ideas or concepts. So much of, I think that the guarding against the runaway design patent claim that so many of my good friends and brethren in the utility patent bar might be concerned about, I think arrive from this idea that design patents, if we were to provide protection for this turtle-shaped mouse, that it's going to stifle competition, and it's going to block anybody from making any type of turtle-shaped mouse. So if somebody were to come along with this other turtle-shaped mouse, be it known that there is no design patent infringement in this particular situation. The same idea, a turtle-shaped computer mouse, but no design infringement. Professor Burstein here has coined an interesting term called concept fallacy, which I think really captures this sort of notion of making sure we interpret and construe design patents in a proper way, giving them a proper scope. It really does have a lot of underpinnings in copyright law with the idea-expression dichotomy. We're probably more familiar with it there. It should apply equally in the design context. So one of the reasons why functionality, I think, has caused a lot of discord in the jurisprudence and confusion is that there are two contexts in which functionality comes in. And when you read the case law, be extra careful because practitioners and courts are jumbling the two concepts all the time. The first is an issue of statutory compliance. Is the design eligible for protection? I give this example of this monkey key, and it was one of the things that you find throughout the book. I sort of take probably a lot of pride in that. There was the work of my own hand is coming up with these images for the monkey key. But it really gets at this concept where you have something that is sort of fanciful and something that we might consider as a very strictly utilitarian, the key blade down below. So first question, statutory compliance. The second question is this idea of claim construction. Are there any aspects, are there any portions, elements, features of that overall appearance that need to be disregarded? And I'll challenge on that second question, and my answer would be, we shouldn't even be asking the question. But nevertheless, if you're going to read the jurisprudence, you're going to see this coming up time and again, that there's this desire to want to ask this second question. Probably more play for the second issue than for the first issue. And the second issue, I think, is the one that's most rife with sort of logical flaws. Statutory compliance issue number one. There seems to be sort of three prevailing approaches that, and I'll say this more sort of on a global scale, sort of worldwide when I saw this issue. How do we know if a design is eligible for protection? Almost everybody agrees that if something is dictated solely by function, if it's dictated solely by technical function, the shape is dictated, sort of preordained. That's the way. If you want to do this thing, it has to look that way. There's great harmonization on that concept, but how do you arrive at whether or not something is dictated by function is where there's a lot of disagreement. The first is the multiplicity of forms theory. That's sort of a fancy name for what we call stateside. Are there alternative designs? Are there alternative ways that you could do the computer mouse? Or if we gave you protection for the computer mouse, would you have a monopoly, a limited monopoly over all computer mouses? Okay? If you can show there's alternative ways to do that, then the argument goes there's no concern, there's no monopoly concern here because other people have other ways in which to achieve that particular functional idea. The second idea is this aesthetic consideration test. This is where, and this is very common in Europe, where they'll look in the mind of the creator. At the time they were creating that scissor blade, were they thinking at all about design? Okay, or were they just thinking only about utility? That test. So now you're looking in the mind of the designer. Then, for instance, in South Africa, there was what they call the matter of concern test, is we're looking in the eyes or the mind of the consumer. Does the consumer care what are the aesthetics of a drill bit when they buy that? So we sort of have these three. One is looking just more objectively speaking, are there alternative designs such that the monopoly concern goes away? Secondly, in the mind of a creator is the European sort of approach. And we're going to look, did they have design? Was that what the only consideration was utilitarian ideas? And then thirdly, like in South Africa and other countries that are looking in the mind of the consumer. Now, unfortunately, here stateside, you see these sort of just jumbled, or you see references to different things all the time of all three of these. I think the prevailing approach is the alternative designs approach, but we've seen even areas of trade dress law sort of infecting over into the design patent jurisprudence. If we hit the statute just up front, we've got we can sort of see where the juxtaposition of the two. We have section 171, which is design patents on the top. This is sort of giving you the subject matter for design patents, whoever invents any new original and ornamental design. And then down below, we see section 101, which we hear about every single day on Law 360 and other scholarship. Whoever invents or discovers any new and useful process machine manufacturer. So you've got ornamental and useful, so you can see that sort of juxtaposition of the two gatekeepers. Now, as a initial point, notice that this does not say any new, original, and non-functional design. Okay, that is, so this is stated as a positive gatekeeper requirement. So just as utility patents is, it has to be useful. If we think about how liberally that particular phrase is interpreted for utility patents, it's just a gatekeeper requirement to get in the door. And same thing with ornamentality. This is not like, in contradistinction to the Lanham Act, where for trade dress, rights that can occur in perpetuity, okay, that there is a requirement that the trade dress be non-functional. Being non-functional is not the same thing as being ornamental. Those are not, they're not saying the same thing. So here is sort of just ornamental to get you in the door. The Supreme Court in dicta has sort of spoken to this issue of what it means to be ornamental, and it sort of said to qualify for protection, a design must present an appearance that is not dictated by function alone. Okay, so that is pretty. When we talk about it, it's been rephrased to say not dictated solely by function. When you say dictated and you say alone, that is extremely narrow as far as things that would be disqualified by protection. It's saying that we will accept a fair amount of function in this and functionally driven design, but they're saying it's by function alone. That's the only thing that's driving this appearance, is your desire to achieve a particular function. Function alone. The Fed Circuit has clinged on, I would say, to the idea of alternative designs, and it's recently talked about. We have often focused on the availability of alternative designs as an important, if not dispositive, factor in evaluating the legal functionality of a claim design. So they're really looking to see is there alternative designs, and looking at that as a key critical feature. And logically, I keep going back to what is the policy reason? What is the reason why we have a functionality doctrine, okay, and I think it's even a misnomer to call it functionality doctrine. It should be called ornamentality doctrine. And whenever I've tried to write scholarship on the area calling ornamentality, people are like, what are you talking about? Because everybody knows it as functionality, but the statute says ornamental. So if anything, it would be nice to really move the dialogue to continuing to use it as ornamentality or lack of ornamentality, as opposed to functionality. Functionality doesn't appear anywhere in 35 USC 171 or anything related to the Design Patent Act. The term is not used at all, so we should be using ornamental. Now, what do we consider alternative designs? And that's sort of a very interesting question as to, okay, I have a tire tread that achieves a particular whisking away or aerodynamic qualities, okay, of traction. Is the only thing that's going to be considered an alternative design is something that achieves that same level of functional qualities, or is it just something that provides positive traction? Okay, so where there could be sort of myriad potential designs which could achieve that. So, but the core here is just that it has to just provide the same or similar functional qualities. So let's give some examples, because I think so many of these issues, it's just best to have visual, and that's my favorite part of practicing design law, is you get to traffic in images and designs. When I was asked to write the book, initially the publisher, Walters Kluwer, said, you can't have any designs. We only do print. We only print text. And I said, I cannot write a design book without any images. So then once it got beyond that, the images were not of, and many of the US patents that we're dealing with were not of sufficient quality for the high resolution printing. So in the book, we have over 350 images, and about 300 of them I had redrawn with a professional draftsperson, so that they're extremely, I think, high quality images, and some of them from some of the most famous cases that we know of in design law. So it's sort of been cleaned up in the book. So I hope you appreciate or enjoy the imagery. So here, back to the monkey key. Statutory compliance. Is this dictated solely by function? First, is this ornamental? And then inversely, I would say, is it dictated solely by function? That's the test. Well, there's other ways. There's certainly other ways that the monkey head could be designed. For instance, you could have chosen any of these other designs. If we were to provide a design right on the key on the left, it would not provide a de facto monopoly over any keys, or things that function as a key. There's many options. Key head, it's probably even easier now. It's all that's claimed here is the key head itself. Whole host of keys, and this is just a sampling of potential designs. And I'm just showing monkey heads. I mean, there's nothing to say. That's just an ornamental key head, so it could be anything. It could be a lion's head. It could be your own image on the key itself. Now, the interesting issue is when you force the issue, and this is what I was saying, sort of getting close to the line, is when you just claim just the key blade itself. Okay, what happens then? Now, there are many key blades that you can choose. You can go into your hardware store and you can see many key blades, but arguably there's only one key that fits a mating keyhole. So this is sort of a question that asks, in this situation, is the only Federal Circuit case where the court has held that it's ineligible, the key blade is ineligible for protection because that key blade was the only form that could matingly engage the particular key at the particular keyhole. Now, this was a 2-1 decision. Judge Newman wrote a dissent in the case, and I think wrote some good issues. What if you designed the key and the keyhole together? Those are both your own creation, okay? So why are we presuming that you are designing this to matingly engage with something that's outside the 4 corners of the document? Who's to say this is even a key? Who's to say that this is not a child's for a child's toy, or perhaps a charm to wear around your lover's neck? I don't know, but it seems like in these cases we take these leaps far beyond the 4 corners of the document to sort of presume what exactly is the particular the design for. So there's been cases where courts have said this is dictated solely by function, so this particular tool was eliminated here on this face guard, softball face guard. The court, if you go down this path, and you'll see it in really poorly written opinions and poorly written briefs, you'll see folks say, well, this is for playing softball, and you have to have those guards there because they protect the softball from hitting your face when you're playing. They have to be a certain width so that the ball doesn't protrude through. You have a chin guard, so it keeps your chin in place. You have the straps on the top. And they say everything, they go down this line about pointing out a function for everything. But it completely misses the point. The statute says, is it ornamental? That is, and is the entire amount of the ensemble ornamental enough to get through as a gatekeeper requirement, not whether or not each particular portion of the design has some type of functional. We're not designing vases here. This is an article of manufacture, is what the Patent Act, the design is protecting. So it's no wonder that there has a function and the components of it have a function. It's the entire thing that's being protected. You have no rights in any independent features of it. If there was something that was old, the bar is old, a bottom bar, we don't eliminate that, right? Because it's that bar in combination with that particular shaped chin strap, with that particular the stripped head bar on the top. Each one of those in combination is what's being protected. So we've seen this in the automobile industry, attacks on eligibility for these. A recent case regarding from the Auto Body Parts Association trying to attack and say, Ford, you shouldn't be allowed to have any protection on any of your car parts because they're functional. They're designed to whisk away the aerodynamics, and there's only one way to whisk away the aerodynamics with that particular mathematical formula, and you shouldn't have protection. Go tell that to Ferrari or Alfa Romeo or Lamborghini or other types of car manufacturers that their design is strictly functional. There's obviously a melding, and a beautiful melding of form and function, and there shouldn't be efforts to try to dissect that. Car treads, I talked to you a bit about that. There's some very interesting litigation if you go back, and if you just sort of, you could almost teach an entire law school course on design regarding tire treads, because it really hits that idea. There is so much of the consumer purchasing decision at the point of sale that regards the aesthetics of the tire. We go in there, you might be thinking, oh, this is all mathematical. The research has shown that much of this in the tires is actually about the appearance, to make them more saleable at the point of sale. But you could see the argument, are there alternatives? Well, if it's the mathematical formulas to achieve that particular tire tread, maybe not. But at the point of sale, it turns out there's a lot of different appearances that could achieve those particular qualities. But then you get some tough cases. You get cases like this. You know, if you had a screw with a sort of your own shaped head, this sort of like a security mounting device, but there are certain types of rivets you might want to design on the head that, for both reasons of aesthetics, you have a nice powder room vanity that you might want to have some nice rivets instead of just having Phillips screw heads or something on there, that you might want to have that and design a particular tool that would engage that. Is this something that is protectable? Here again, even though the rest of it might be totally, have very functionally driven, the head is not, therefore the overall appearance is not, and therefore it would most likely pass muster under the Section 171. Now, some other courts, I would be remiss if I didn't mention that some courts don't just use an alternative designs type of test. They don't simply look, are there alternative designs? If there are, then that means that there's not a monopoly concern. And even if there's only a handful, I've written that we shouldn't be so much on the lookout for, you know, preventing monopolies, but maybe even oligopolies, in the sense that where there's maybe a handful of types of designs. If you could sort of corner 2 or 3, and then you could corner that particular functional idea, that may be sufficient. But here, this is where what I was saying before about courts just uprooting and taking the 5-factor, the Morton-Norwich factors from trade dress law, and pumping them over into design patent law and trying to apply with them there. There is, in the papers you can read about that, but I have problems with doing that because I think that they're apples and oranges, design rights and trade dress rights, both in term and protection and policy. So let's hit on the second issue here, just trying to keep an eye on the clock here as we go through it. Are there any aspects of the design? So now here we're talking about, are there any particular aspects of the design that are to be eliminated? We've got some case law that was on both sides of this issue. Here's Judge Laurie in 1995 in the Elmer case. And I always like to set up my slides. I find this helpful in front of whether fact finders or juries or judges, chronologically from left to right. Because in designs you start seeing these things getting jumbled with the prior art on the right and the accused product. I usually try to put prior art, design right, accused product, both in the book and on my slides, so it's always going to be sort of chronological from left to right, like reading a book. But in any event, in this case, the plaintiff said, well, I know they're not in the accused product, but Your Honor, you should not pay attention to those because those are functional features. So this is an interesting case because it's the plaintiff patentee who's trying to eliminate features of their own design, saying that the protrusion on the top and these wings, these ribs, were functional, they therefore should be disregarded. But Judge Lurie sticks it to him and says, now, you put them in solid lines in your drawings. They're part of the overall claim design. You could have dotted those things out back at prosecution, but you're stuck with them now. So this to me always seems to be the more appropriate approach. You, as the patentee, are the master of your claim. If you want to reduce things to dotted lines and disclaim them, do it. But otherwise, if they're in the claim, if they're in solid lines, they're part of the overall claim. And whatever's in solid lines has to pass ornamentality, has to pass novelty, has to pass non-obviousness. If you only claim the support rib on the side, well then maybe that's more like just claiming just the key blade. You know, once you start trying to push it to that line, you do so at your own peril. Judge Lurie, a couple years later, in the Oddson case, now sort of did a flip-flop though. It said, well, the tail and fins are dictated solely by function and thus are not part of the claim design. So 1995 says that you're stuck with them, they're in the drawings. 1997 says they're dictated solely by function, these features, and are not part of the claim design. And it's after this case that the wheels just come off. You see in all of these cases, people just dissecting designs and eliminating particular features. And the court sets forth this dicta, which I say is completely wrong. Design patents, when it says design patents only protect the novel features, you don't just go into a design and say, well, that's a new feature, that one's old, we're going to kick that out, that one's sort of old, we'll keep. It's, again, a combination. But this thing, you'll see in almost every defendant's accused infringer's brief, you're going to see this particular statement. And then it all sort of culminates here at the Federal Circuit in Richardson v. Stanley Works, where it's sort of the case where they did the ultimate divide and conquer. The court says, Richardson multifunction tool comprise. First of all, the court said the overall appearance passes muster on question 1. It is ornamental, the overall appearance. But then used this backdoor attack by saying all these features are driven purely by functional. The handle, the hammerhead, the jaw, and the crowbar. So the court says that those features need to be discounted, ignored, factored out. And this is what they do. It's like break out the eraser and you start eliminating features right through the claim until you're left with claim construction turning into claim destruction. Now, I will say that if you practice a lot in copyright law and you practice a lot in trade dress law, maybe this doesn't seem so foreign to you, where you are eliminating features. Now, there's other things at play in both of those particular areas, but in a design right where you have a claiming system, a before the fact, an ex ante claiming system where you're saying this is my claim, this sort of post hoc, ad hoc elimination of features it belies and betrays the design of the designer in the first instance. So the courts have gone along and eliminated features, and suffice to say here in this case, they eliminated the middle feature, saying giving it it's the blade, the locking means it's not entitled to design protection. Well, nobody ever said that that was entitled to protection. What's entitled to protection is the entire thing. So it's just like I was saying in a utility patent, if you have five claim elements, you don't have any independent protection in the wheels, the fifth claim element. It's only in, so the protection that would be provided in that blade would be in combination with the handle itself. So I want to make sure we just sort of get to sort of the bottom line here is that why we can't do this, okay? Why we shouldn't be eliminating features, and it's of course outlined in much more detail in the book, is it fails to look at the overall design. That's what the monopoly right is all about. That's, I mean, the design patent limited monopoly is the overall, so why are we tinkering with that after the fact? It's frankly unworkable if you're dealing with whether a jury system or any type of fact finder where you have, imagine a large painting and you're telling, ignore that element, that element, that element, and that element. So it's like a piece of Swiss cheese. That's unworkable. It undermines the presumption of validity, that these are presumed to be valid. It provides this sort of backdoor. If you have to show that the overall design is invalid, you're going to have to show by clear and convincing evidence, and all the niceties that cloak an attack on validity of an issued patent. But here, you can just go through claim construction and do, by the preponderance of evidence, just eliminate each one of the four factors, or the four elements, for instance, in that Richardson case. And then fifthly, why are we doing this as part of claim construction? It's always a fact question when we're talking about functionality in other contexts. Why would we leave this with the court as far as for claim construction? So let me get to I want to get here to the good news. So the good news is that after all of this, there's been 3 cases from the Fed Circuit, and we're going to close with these 3 cases because I think they leave us to where we're at right now. Apple v. Samsung, Ethicon, and Sport Dimension, all after 2015, a trio of cases, all which happened to come out after I wrote the other article you have there called Design Patent Functionality, A Sensible Solution. where I was sort of pointing out the madness of, and the chaos in the case law by doing this, eliminating features. And it came, this whole attack reared its head in Apple v. Samsung. And here is Samsung arguing that things like the rounded corners, the rectangular shape, the positioning, that those are all functional features and therefore should be disregarded when comparing to the accused product. Okay, so if they can eliminate all these features, what are you sort of left with? Nothing, right. And there wasn't too much, there wasn't too much, in fairness to Samsung and their attacks, there isn't too much that's claimed in this in the first instance. But the proper attack is novelty, find it in the prior art. Non-obviousness, show that it's obvious to one of ordinary skill in the art. Lack of ornamentality, show that there's no alternative designs. Now, you would hear this cry that there are no alternative designs. Sit down with an industrial designer and show them this, and you tell them, are there any ways, alternative ways to design this? And you're not going to find a single one that's going to say, I give up. Apple's got it. They got the only way to design a smartphone. They're not going to say that. In these cases, I've always found it helpful. Take a walk over here to the Art Institute, the School of Designed Objects, or go over to UIC, to the Industrial Design School. Come up with your 5 criteria of what you need for the design, and time again, they'll come up with a whole sheet of 100 different alternative designs. Okay, and on one side, you could be jaundiced and say, well, this is making a mockery of the ornamental requirement in the statute. But what's the policy reason that this is getting at? We're trying to prevent any types of monopoly, and the reality is it's very difficult to monopolize a functional idea with a particular design. There's usually always going to be alternative designs, and that's a good thing. That is not necessarily a problem. It's a virtue of the system, not a problem. So the Federal Circuit, Apple v. Samsung, said, Richardson did not establish a rule to eliminate entire structural elements from the claim scope, as Samsung argues. I sort of feel bad for Samsung here, because that really is precisely what the court said in Richardson, and the court says you do not eliminate these features in the entirety. It says the claim construction included the ornamental aspects of the components. So now they're saying you keep the elements in there, but what's being protected is the particular expression. And it's like, thank you for going back to the fundamental idea that designs do not protect general concepts, they protect the expression. And they said the standard shape of the hammerhead. So a standard that could have been used for 100 years in that particular form, that's part of the overall amalgam. The diamond-shaped flare of the crowbar, the rounded neck, the orientation of the crowbar, and the plain, undecorated handle. So even the lack of ornament is ornamental. And it's all, what was really nice about this was basically saying, it's what the drawings show. We're not going to go through and eliminate any features. Old habits die hard. Hefticon v. Covidian, cases going through the system. Now we're getting to medical devices. Judge Chen, 2015. This device has a torque button, an activation button, and a trigger. Torque knob, activation button, and a trigger. Same old attack. Defendant comes in there, tries to do the divide and conquer. Torque knob functional, activation button functional, trigger functional. We got to get rid of them all, and then you're left with, what are you left with? Nothing. And Judge Chen doesn't take the bait and says the district court's construction of design patents that have no scope whatsoever fails to account for the particular ornamentation of the claim designs and departs from our established legal framework for interpreting design patent claims. They agree that the trigger, the torque knob, the activation, they all have underlying functional aspects. So they say, do not touch it. And then the last case here, which we'll sort of finish with, is the sport dimension. Same attack here, tried to eliminate, saying the side torso tapering was functional, the armband. If you're asking the question whether something is functional, you're asking the wrong question. And the court said, we do not eliminate entire elements. It's contrary to our law. So let me just get to the sort of, if I could have a sort of a restatement, a clear restatement of law on the idea of this functionality issue would be that a design patent only protects and get rid of all of this feature aspects, elemental, atomization type of talk, and get back to what the monopoly right is intended to provide, and that is the overall appearance which you've claimed in your design. It protects the overall appearance of the design as depicted in the drawings. It does not protect functional qualities or general design concepts. A very interesting, I mean, it was a huge learning experience going through the book because was able to get fact patterns from, 27 jurisdictions worldwide, where in the States, we might have, I don't know, maybe, 50, 100 cases. Here, you're able to deal with, hundreds of them. So anyways, I'm happy to take any questions on this question. And as far as, buying the book, Wolters Kluwer is really tight on me. They don't give you any samples of the book, but they certainly can just be bought online, either on Amazon or also on Wolters Kluwer's website. Thank you.
Thank you, Chris. We do have time for some questions, so if anyone has questions, speak loud, and then I will repeat the question so that we have it properly on our video here, and then Chris can answer.
Sure.
So, any questions? I'll be happy to start us off while people are thinking. Anyone?
I'll ask
Yes.
a question.
Sure.
So in your book, you say that the technical features should not be discarded,
Right.
right? I believe.
Correct.
So-
The appearance of any technical features. So, but finish your question.
Okay. So in some of the examples that you presented, there seems to be inconsistency between eliminating the functional features or what considered to be and keeping them depending on who renders the opinion. So how do you navigate all of that?
Yeah.
To just
Yeah.
capture the question, the point that technical features are not to be discarded, there's some issue that there maybe are some inconsistencies about that, and how do we navigate that?
Sure. I think the key is because you're going to be confronted with a lot of case law which says that design patents do not protect functional features or attributes. It's making sure, what do we mean by a functional feature or attribute? Do we mean the physical manifestation of that feature? Or is what the law is really saying is that those abstract underlying qualities that is not protectable? So you've got a pair of scissors and, maybe they're something that you would see on a chef's kitchen or something like that. It has a particular appearance. You're not going to eliminate the blades themselves, but whether or not they are good at cutting or bad at cutting, that's what's immaterial. So I think in front of courts, if you're trying to impress upon them, how do you distinguish this case law, which keeps sort of grossly saying you have to eliminate functional features, is they're talking more about abstract qualities and not the physical manifestation of those features. I gave the example about the hinge, right? The hinge there, you don't eliminate the hinge, Your Honor. Whether or not that's the fact that it swivels or doesn't swivel or swivels really well or not, that's what should be disregarded.
Yes, in the back?
Generally speaking, if you had to pick 3 cases to rely on to educate a judge, a jury, or anybody in an infringement situation, what would those cases be? You only got 3.
Okay.
Good question. The question is, if you only had 3 cases to educate a judge or a jury on these issues, what would those be?
Okay. So to clarify, on the functionality issue or just in design law?
Generally speaking.
Oh, generally speaking, design law. Okay, sure. Well, I think you would really want to start with Gorham v. White. It is such a bedrock case, and the visuals are good. I think it sets, and I'm going to take this from a patentee's perspective, okay? I think it serves as a nice visual barometer as far as how close is too close in a design. It really isn't. If you look at the 2 designs, and we'll look at them here afterwards, it's not exactly true. There's quite differences in form and also in detail. So I think Gorham v. White's a great case. Sort of maybe a more modern day version of that is also the Crocs case, Crocs versus ITC, which is sort of a helpful case in showing that just getting away from the literalism that's often accompanies design patent protection is that there you had those Crocs shoes. Some people think they're nice, some people think they're really ugly, but there was differences in shape and in holes, and some had holes, some had diamonds, and nevertheless the court found that there was infringement. And then I think probably one of the other issues, and here we'll have to drift into one of some of the other issues of design, the Lytton Well, I would say probably Egyptian goddess. I think Egyptian goddess in 2000 and 2008 would have to be on that list, just because it gutted out so much of the chaos that proceeded for the prior 15 years. And I can remember at the time leading up to that, there was some of us who practice a lot in this area saying, why are we even bothering with an examination system in the US for designs? We should just scrap it all, because our presumption of validity doesn't mean much for obviousness or novelty or functionality. We should just go with a registration system. You know, to get from point A to B, you don't always need a Cadillac. A Chevy will do. So you can, and that's, most of the rest of the world, they don't do full-blown examinations. The thought here is we'll do a full-blown examination, you have a more solid right. But when the case law was in such bad shape, it seemed like it wasn't worth the fight.
Any others? I'll pose one to you. As a copyright lawyer and professor sitting here, I was kind of fascinated by the amount of overlap of terminology and concepts that you were talking about. And a couple of things just jumped out at me. I'd like to get your thoughts on this. The test, I guess, for infringement for design rights would, I believe, use the term substantially the same. Is that from the
Correct.
case law or the case law?
Yes.
Okay. Versus substantially similar in copyright. I presume substantially the same is narrower than being substantially similar, and maybe not. But do the courts in design cases use those terms? Do they ever use substantially similar by mistake?
I see that the language is verbatim, substantially the same from the Gorham v. White test.
Okay.
So when they probably mean the same thing. I haven't seen it sort of quantified, but if you're a plaintiff's attorney and you do use substantially similar, I've seen many of the defendants pounce on it and say, hey, you're trying to use a watered down standard instead of the substantially the same standard. But I think that, a lot of the terminology is the same, but I think there's should be distinctions in some of it.
Another term I heard that was the same word, probably very different meanings, or maybe not identical meanings, was in the statute where it said original. Did it say novel, original, and ornamental?
Sure.
So in copyright, original means, it's a pretty loose meaning of originality. It simply means not copied from someone else. But what does original mean in design patent?
You ask dangerous questions. No, in the
We can
sense.
go back and just-
No. It is one that rare. I mean, there's, and I'm sure Professor Burstein could comment on this. There's just so little on originality, even though it's odd. I mean, it's right there, front and center in the statute, and occasionally you'll see an examiner or two double bag it and say, to reject you for novelty and then reject you for originality. But there's really no case law to support it. I think the limited case law there is speaking of this nature, that it's original to you, but there really isn't much on that, on originality.
And is it the same as non-obvious?
No, now that's a separate, now that comes from a section 103, and there you're looking at the difference between the prior art and your patented design. So what is the delta between your design and what existed in the prior art? And then the question is whether or not that delta, that difference, would have been obvious to one of ordinary skill in the art, or a designer of ordinary skill in the art. But that really, much of that jurisprudence is an outcropping from utility patent law that sort of has found its way into designs, and whether or not it makes sense or not, we can save for another day.
Yes.
Could it be presumed that the originality factor isn't prosecuted, if you will, in regard to claims because of the presumption of validity? And like, that's one of the strongholds of it, that going through the examination, you kind of get the stamp that this is original if it's approved already?
Again, to restate, I think the question was with respect to originality, that it's not prosecuted that often is because of the presumption of validity.
Yeah, I mean, You have to, in two contexts, right? Because first you have an examination context where you're before the office, and so that's where I have seen it. In a litigation context, an enforcement case, I personally haven't seen it. I know there is a smattering of cases, about 4 or 5 cases, but I guess really there, your novelty would get you in most of the situations. Where you have seen it is, for instance, original. If it is something that occurs in nature, you have a shape of a pear or something like that that you found on a tree, and then you turn that into a mold for something, that is not going to be original to you. That's something derived from nature. But it seems like it's in such rare circumstances that it's seen. But maybe something we can have over a drink at the reception. Rand, economy.
With regard to the reasonable observer test, it says that the reasonable observer finds the design so similar that they would mistake one for the other. But what if you have other indicia that makes them different? For example, for tractors, instead of red, you have green for John Deere, or you actually put a trademark on the product so to differentiate that from the other design. How does that affect
Sure.
the substantial similarity in the eye of the observer?
Okay. Good question. Sure. So the question is, when you have, doing your comparison purposes for infringement, what about other externalities that might be involved in the process that might detract from a finding of deception or thinking one to be the other? He gave examples of color or maybe trademarks or other type of labels on the product. This really gets to the idea of going back to what is the claim. You as the applicant are the master of your own claim. If you included in your claim color, if you included label or logo, that might be part of your design. But most practice, you're going to eliminate that. That comparison, as you were talking through it, really sounds like a product-to-product comparison. It's very important in the design context that you're looking at a patent to product comparison. So if in your patent you don't have those types of colors, claims, it's going to be considered, for instance, black and white line drawings, you're not going to be limited to a particular colorway. There is case law that says that as far as an accused product, if you put a label on it or adding to it like that those are not going to be considered to be non-infringing considerations that you should be looking at. So I think the key to that question, though, the answer is that you should be looking just at the patent, whatever's in the patent, comparing to that. This really, though, hits on a big topic which is unsolved, is are design patent claims open claims or closed claims? If I want to use utility patent languages, are design patent claims comprising claims or consisting of claims? Think about that, and I'm not even going to go into it, but maybe over a drink we can talk about it. Yes?
We have time for one more, yes.
And I don't know, maybe that's a segue into my question. I work with the trademark clinic here, and when you bring in the concept of the overall appearance, it brings me into a trademark mind, because when you're filing a trademark application or worried about the possibility of there being a junior or somebody out there with substantial similarity, you're looking at the totality of the trademark. Do you see at times that, you know, jurists or even other attorneys, maybe even defense attorneys, or even the claimant themselves are possibly confusing the distinctions of the two claims because you're looking at the overall appearance?
Yeah. So, right, so one of the gist there is that when you have your design that you're set forth, say you don't claim everything, you only have portions of the design, but portions are disclaimed. Does the fact finder sometimes get confused by only looking at the claim portion, and do they get confused by including the sort of unclaimed portion? I gave the example with the webcam, okay? So say, for instance, you had the claimed upper housing, the bottom shows a C-clamp. And then the accused product, you have the same identical upper housing, but you have a J-clamp or an L-clamp, you know? Do they do they get confused upon that name non-claimed portion? I think that it can, and that's why I do, instead of, some people might just put a broken wavy line and not show what's down below. In some instances, it's helpful to have that other information, albeit shown in dotted lines, because it provides context, it provides sort of spatial relationships, it provides, so it can actually be helpful, and I do find that it does find its way often to the minds of fact finders, even subconsciously, it's there.
It's kind of like that, oh, scratch that from the record, but it's already there.
Yeah, you can't get it out of you.
All right, we can continue the discussion in the back of the room, and so please join me in thanking Chris Carani.